Alrighty, so the Federal Court of Appeal for the 7th District just dismissed another one of Donald Trump's lawsuits, and the decision raises a few questions. Viva Frei, Montreal litigator turned YouTuber, and yes, I am obviously not in my standard office. I am in a cottage, and my wife said if you sneak away to do a vlog, at the very least,
don't sneak back into the bathroom to do it.
Alright, setting all that aside, forget about the backdrop because this is all about the judgment. The judgment coming out of the Federal Court of Appeal for the 7th District certainly, in my humble opinion, raises quite a few questions given the basis upon which the Supreme Court just dismissed Texas's lawsuit against Georgia, Michigan, Pennsylvania, and what was the other one? Wisconsin. But before we get there, let's just jump right into the decision itself. In the United States Court of Appeals for the 7th Circuit, Donald J. Trump, plaintiff appellant versus Wisconsin Elections Commission et al. Defendants appellees. Appeal from the United States District Court for the Eastern District of Wisconsin, Brett H. Ludwig, Judge. Submitted December 21, 2020, decided December 24, 2020, before Flom, Rovner, and Scooter circuit judges. Now, just to get this out in the open right away, because I know a lot of you are probably asking the questions, the three judges, Flom, Rovner, and Scooter, are respectively Reagan, Bush, and Trump appointees. So if you were going to look for political bias to explain away this decision, you're going to have to factor in the fact that these three judges were Republican appointees by Reagan, Bush, and Trump himself. And now an interesting footnote that you might have already noticed. We have agreed to decide this case without oral argument because the briefs and record adequately present the facts and legal arguments, and oral argument would not significantly aid the court. And they cite the federal rules of procedure that allow for proceeding accordingly. And now the judgment, and now I'm also realizing that the lighting is terrible and doesn't make me look particularly good, but whatever, this is about the judgment, it's not about my face. 2 days after Wisconsin certified the results of its 2020 election, President Donald J. Trump invoked the Electors Clause of the U.S. Constitution and sued the Wisconsin Elections Commission, Governor, Secretary of State, and several local officials in federal court. The district court concluded that the president's challenges lacked merit, as he objected only to the administration of the election, yet the Electors Clause, by its terms, addresses the authority of the state's legislature to prescribe the manner of appointing its presidential electors. So too did the district court conclude that the president's claims would fail even under a broader alternative reading of the Electors Clause that extended to a state's conduct of the presidential election. We agree that Wisconsin lawfully appointed its electors in the manner directed by its legislature, and add that the president's claim also fails because of the unreasonable delay that accompanied the challenges the president now wishes to advance against Wisconsin's election procedures. Now, if this sounds somewhat familiar, it should, because this is very similar to the basis upon which Texas sued Georgia, Michigan, Pennsylvania, and Wisconsin, in that they violated the Electors Clause of the Constitution in the manner in which they conducted their state elections. Texas's argument was that the defendant states unconstitutionally modified their election laws, their state election laws, but in such a manner that violated the Elections Clause in the Constitution, and Texas's prejudice was that its lawfully dictated votes were diluted by the fact that these defendant states did not follow their own election laws, unconstitutionally modified their election laws, thus violated the terms of the Electors Clause in the U.S. Constitution. That was Texas's argument, and the Supreme Court, in a now infamous two-line judgment, said Texas lacked standing and the Supreme Court was not the proper venue, in that only the states were in the proper position to interpret state law. This led to some heated debate among the YouTube lawyers out there, some of whom felt that this was a no-brainer of a decision, others who didn't think that this made entirely all that much sense, or at the very least that Texas had standing, had a legitimate complaint, and even if the lawsuit was going to get dismissed, at the very least they had to enter into the merits and properly justify their decision. The judgment then summarily summarizes the facts and brings up the arguments that Donald Trump raised, so let's just go over those very quickly. On November 3, the United States held its 2020 presidential election. The final tally in Wisconsin showed that Joseph R. Biden Jr. won the state by 20,682 votes. On November 30, the Wisconsin Elections Commission certified the results. The governor signed an accompanying certification, and Wisconsin notified the National Archives that it had selected Biden's 10 electors to represent the state in the Electoral College. 2 days later, the president brought this lawsuit challenging certain procedures Wisconsin had used in conducting the election. The president alleged that the procedures violated the Electors Clause of the U.S. Constitution. Each state shall appoint, in such manner as the legislature thereof may direct, a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. United States Constitution, Article 2, Section 1, Clause 2. Again, if this sounds familiar, it should. This is virtually identical to the argument raised by Texas in suing Pennsylvania, Georgia, Wisconsin, and Michigan, in that they allegedly did not follow their own laws as relates to the elections, thereby violating violating the Electors Clause. The alleged prejudice to Texas being that it followed the rules and its votes were now going to be diluted by 4 defendant states who did not follow the rules. The judgment then explains what Wisconsin did, ostensibly under the guise of the Electors Clause. To implement the obligation imposed by the Electors Clause, Wisconsin's legislature has directed that the state's electors be appointed, quote, by general ballot at the general election for choosing the President and Vice President of the United States. It has further assigned, quote, responsibility for the administration of laws relating to elections and election campaigns, end quote, to the Commission. Municipalities run the election, and each municipality's own clerk, quote, has charge and supervision of elections and registration in the municipality, end quote. The President alleges that the Commission and municipal officials so misused the power granted to them by the legislature that they had unconstitutionally altered the, quote, manner by which Wisconsin appointed its electors. His allegations challenge 3 pieces of guidance issued by the Commission well in advance of the 2020 election. We then go over the 3 arguments raised by the Trump campaign, and if the first one sounds familiar to you, it should. It's virtually identical to the argument raised by Texas in its lawsuit against Wisconsin. First, in March 2020, the Commission clarified the standards and procedures for voters to qualify as, quote, indefinitely confined, end quote, and thereof be entitled to vote absentee without presenting a photo identification. The Commission explained that many voters would qualify based on their personal circumstances and the COVID-19 pandemic, adding that Wisconsin's law established no method for a clerk to demand proof of a voter's individual situation. The Wisconsin Supreme Court endorsed the Commission's interpretation when it enjoined the Dane County clerk from offering any contrary view of the law. Second, the Commission issued guidance in August 2020 endorsing the use of drop boxes for the return of absentee ballots. The Commission explained that drop boxes could be, quote, staffed or unstaffed, temporary or permanent, end quote, and offered advice on how to make them both secure and available to voters during the pandemic. Actually, this second argument should also sound familiar because it is also an argument raised by Texas in its lawsuit against the 4 defendant states that was summarily dismissed by the Supreme Court of the United States. And last but not least, third, 4 years ago before the 2016 election, the Commission instructed municipal clerks on best practices for correcting a witness's address on the absentee ballot certificate. Clerks were able, the Commission explained, to contact the voter or witness to use another source or reliable information to correct or complete address information on an absentee ballot. The President's complaint alleges that the Commission, in issuing this guidance, expanded the standards for, quote, indefinitely confined, end quote, voters, invited voter fraud by authorizing the use of unstaffed drop boxes, and misled municipal clerks about their powers to complete or correct address information on absentee ballots, all contrary to Wisconsin statutory law. The President sought declaratory and injunctive relief on the view that these alleged misinterpretations of state law, quote, infringed and invaded upon the Wisconsin legislature's prerogative and directions under the Electors Clause of Article 2 of the U.S. Constitution, end quote. Ultimately, the district court did in fact dismiss the campaign's arguments for the following reason. After an evidentiary hearing, the district court rejected the President's claim on the merits and entered judgment for the Commission and other defendants. The Electors Clause, the court determined, addressed the, quote, manner, end quote, the, quote, approach, form, method, or mode, end quote, by which Wisconsin appointed its electors. For Wisconsin, that meant only by, quote, general ballot at the general election, end quote. With the court further observing that any mistakes in administering the election did not change that the electors were appointed by general election. More simply put, the court concluded that even if they made mistakes in administering the election, they nonetheless conducted the election by general election and therefore basically did it in the manner prescribed by law. But just to be certain, the court went on to add the following. Even if the Electors Clause was read more broadly to address the, quote, manner in which Wisconsin conducted the election, the district court determined that the legislature had authorized the Commission to issue the guidance now challenged by the President. None of that guidance, the district court reasoned, reflected such a deviation from the Wisconsin legislature's directives as to violate the Electors Clause. Now, in my humble opinion, this is among the most important things in this judgment, in that the district court is basically saying, look, nothing they did deviated so radically from the rules that it could violate the Electors Clause, which seems to implicitly recognize that it would be theoretically possible for them to violate the rules so egregiously that it would in fact violate the Electors Clause. The court concluded that even if there were deviations, they were not substantial enough to violate the Electors Clause, which necessarily means that there are, in theory, certain deviations so serious they would violate the Electors Clause. So the court needs to determine if the President has standing to file the suit, if the court has jurisdiction, and they determine that yes, the President does have standing, they do in fact have jurisdiction, and they're going to dismiss the lawsuit, but the reasons for which they determine that they have standing raise a lot of questions. We begin, as we must, by asserting whether the President has presented a case or controversy over which we have jurisdiction. The inquiry turns on the doctrine of standing, and more specifically whether the president has alleged an injury traceable to the actions of the defendants and capable of being redressed by a favorable judicial ruling. The district court answered the question in the president's favor. We do too. The district court answered it in the president's favor so they could subsequently dismiss the lawsuit, whereas the Supreme Court did not answer that question in Texas's favor, and you tell me how you can reconcile these two judgments and the reasoning in them. On the injury prong of standing, the president has alleged, quote, concrete and particularized harm stemming from the allegedly unlawful manner by which Wisconsin appointed its electors, as did Texas. The alleged injury, in fact, is likewise, quote, fairly traceable, end quote, to the challenged action of the defendants, all of whom played some role in administering the election. I appreciate that there are differences, but I would argue that this applies perfectly mutatis mutandis to the arguments raised by Texas. Texas alleged that it suffered a prejudice as a direct result of the actions of the four defendant states in the allegedly unlawful manner in which they conducted their elections, and the redress would have been identical to that which President Trump was asking for here. But it is the final requirement that the court adjudicates upon that is really going to blow your mind. The final requirement for Article 3 standing, that the alleged injury, quote, likely would be redressed by a favorable decision, presents a closer question. Were we to grant the president the relief he requests and declare the election results void, the alleged injury, the unlawful appointment of electors, would be redressed. True, our declaration would not result in a new slate of electors, but the fact that a judicial order cannot provide the full extent or exact type of relief a plaintiff might desire does not render the entire case non-justiciable. A favorable ruling would provide the opportunity for the appointment of a new slate of electors. From there, it would be for the Wisconsin's legislature to decide the next steps in advance of Congress's count of the Electoral College's votes on January 6, 2021. All of this is enough to demonstrate Article 3 standing. But it is the last paragraph on the court's consideration of standing that is absolutely going to blow your mind, and that, in my humble opinion, seems to be totally irreconcilable with the decision that just came out of the SCOTUS. We also conclude that the president's complaint presents a federal question, despite its anchoring in alleged violations of state law. The 11th Amendment and principles of federalism bar federal courts from directing state officials to follow state law. But we can decide whether their interpretation of state law violated a provision of the federal constitution, here the Electors Clause. This distinction alleviates any federalism concerns that might otherwise preclude our consideration of the president's claims. The inverse of this reasoning was the exact reason for which the Supreme Court denied Texas standing and refused to hear Texas's lawsuit in the first place. The exact opposite reasoning was used to dismiss Texas's case on the basis that Texas had no standing to file the case before the Supreme Court. The court then goes on with the wonderful reasoning that they are not in the best position to interpret state law. That is up to the district court, but even if they were to interpret state law, they would not find any conclusions of wrongdoing. But even if they were to find conclusions of wrongdoing, President Trump would be barred by the theory of the latches. In other words, it might seem to some that the federal court basically gave standing to Donald Trump solely for the purposes of dismissing his lawsuit. On the merits, the district court was right to enter judgment for the defendants. We reached this conclusion in no small part because of the president's delay in bringing the challenges to Wisconsin law that provide the foundation for the alleged constitutional violation. Even apart from the delay, the claims fail under the Electors Clause. The court then goes on to describe the theory of the latches, which is the idea that if you wait too long to avail yourself of your rights, you are basically barred from availing yourself of those rights, and latches comes from the French word lâche, which means lazy or people who don't do things in time. The same imperative of timing and the exercise of judicial review applies with much more force on the back end of elections. Before a court can contemplate entering a judgment that would void election results, it, quote, must consider whether the plaintiffs filed a timely pre-election request for relief, end quote. These very considerations underpin the doctrine of latches. At its core, latches is about timing. Quote, latches cut off the right to sue when the plaintiff has delayed too long in suing. Too long for this purpose means that the plaintiff delayed inexcusably and the defendant was harmed by the delay. End quote. Allowing the president to raise his arguments at this late date after Wisconsin has tallied the votes and certified the election outcome would impose unquestionable harm on the defendants and the state's voters, many of whom cast ballots in reliance on the guidance, procedures, and practices that the president challenges here. The president's delay alone is enough to warrant affirming the district court's judgment. But just so you don't feel that the court is dismissing the lawsuit too quickly, they say that even if we were not to dismiss this lawsuit on the theory of the latches, it would still fail on the merits. The president would fare no better even if we went further and reached the merits of his claims under the Electors Clause. Recall that the Electors Clause requires each state to, quote, appoint in such manner as the legislature thereof may direct, end quote, presidential electors. By its terms, the clause could be read as addressing only the manner of appointing electors and thus nothing about the law that governs the administration of an election. Historically, the states used a variety of manners for appointing electors, such as direct legislative appointment. For its part, the Wisconsin legislature has consistently chosen a general election to appoint its electors. The complaint does not allege that the Commission's guidance documents shifted Wisconsin from a general election to some other manner of appointing electors, like those used in other states in the past. On this reading of the Electors Clause, the President has failed to state a claim. Again, the manner in which this is drafted would suggest that there would be a manner in which Wisconsin could have violated the Electors Clause in the manner in which they conducted their elections. The court is just saying this is not one of those examples, so we're dismissing your claim on the merits even if we were to get there, although we've just dismissed it on the theory of the latches. And in support of its conclusion, the Court of Appeal writes as follows. The Wisconsin legislature expressly assigned to the Commission, quote, the responsibility for the administration of laws relating to elections, end quote. Just as Florida's legislature had delegated a similar responsibility to its Secretary of State. Florida's legislative scheme included this, quote, statutorily provided appointment of responsibility, end quote, and 3 justices found a departure from that scheme when the Florida Supreme Court rejected the Secretary's interpretation of state law. And it was the Minnesota Secretary of State's lack of similar responsibility that prompted 2 judges of the 8th Circuit to conclude that he likely violated the Electors Clause by adding a week to the deadline for receipt of absentee ballots. By contrast, whatever actions the Commission took here, it took under color of authority expressly granted to it by the legislature, and that authority is not diminished by the allegations that the Commission erred in its exercise. The court is basically concluding that they may have made mistakes in the manner in which they conducted the elections, but they were not such big mistakes. They did not deviate so radically that they violated the Electors Clause, which admits of the possibility that there are such circumstances that may exist. But the final paragraph is the best. We confine our conclusions to applications of the Electors Clause. We are not the ultimate authority on Wisconsin law. That responsibility rests with the state's Supreme Court. Put another way, the errors that the President alleges occurred in the Commission's exercise of its authority in the main matters of state law. They belong then in the state courts where the President had an opportunity to raise his concerns. Indeed, the Wisconsin Supreme Court rejected his claims regarding the guidance on indefinitely confined voters, see Trump v. Biden, and declined to reach the rest of his arguments on grounds of latches. For our part, all we need to say is that even on a broad reading of the Electors Clause, Wisconsin lawfully appointed its electors in the manner directed by its legislature. For these reasons, we affirm. Now, don't take this as a criticism of the decision itself. I don't consider myself to be in a position to criticize this decision on the merits. All that I am saying is that the rationale used in this decision ought to have applied to the SCOTUS dealing with the Texas lawsuit, and there was no logical basis for the SCOTUS to dismiss the Texas lawsuit on the basis of standing, whereas this federal court agreed that there was standing and agreed to hear the case.
We also conclude that the President's complaint presents a federal question despite its anchoring in alleged violations of state law.
Unless I am misreading or misunderstanding something, that rationale applies perfectly and identically to the Texas lawsuit against the 4 defendant states, and the SCOTUS had no business dismissing that lawsuit the way they dismissed it, especially in light of the reasoning in this decision. It might not have changed anything on the outcome, but it would certainly have changed something on the procedure, and sometimes more important than the outcome is ensuring or giving the appearance that proper procedure is being followed. So regardless of whether I agree or disagree with this particular decision, it certainly raises some questions in what the SCOTUS did in dealing with the Texas lawsuit. And with that said, if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm.
You can do it, Bellissimo.
If you want to support the channel, all of these support links are in the pinned comment, but more important than that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well. Most importantly, Merry Christmas, and now you know your vlog. Peace out.